Another federal court has ruled that federal laws on possessing machine guns are in fact a violation of the Second Amendment. And now AG Pam Bondi and the Trump administration have been put on a deadline, and they have to decide what they want to do in this case and how do they want to proceed forward on this machine gun issue. So let's break down what is happening. Now, really quick before we jump into this video, if you want to support the channel for free, one of the best ways to do that is simply subscribing. Also click on all notifications if you click the notification bell, because that helps to ensure that YouTube will actually send you these videos. And then simply just drop a positive comment down below, because that helps tell the algorithm that you appreciate the type of 2A content and that it should share it and send it to more people. Now, like I mentioned in the intro, in this video, we're going to be talking about a very important machine gun possession case, and it's going to put the AG's office and the Trump administration on notice, and we're going to find out very soon what their new position on machine guns actually is and how are they going to proceed forward in this case. Recently, another federal district court dismissed a machine gun possession charge based on the Second Amendment and based on the Supreme Court's recent Bruen decision. This is a huge win. It was a huge case striking down machine gun restrictions as a violation of the Second Amendment. Just within this year, we've seen 2 federal district courts actually issue decisions striking down these type of machine gun possession charges. This decision we're going to be talking about came in a Mississippi district court, and it came from Judge Carlton Reeves in a case called U.S. versus Brown. However, like I said, there are 2 cases. The other one is U.S. versus Morgan, and in that case, there was a similar as-applied challenge based on the Second Amendment. In this case here, Brown used the Morgan decision out of the district court there, which is now also appealed to the 10th Circuit. They used that decision to once again strike down another machine gun possession charge. But this case, Brown, is now being appealed to the 5th Circuit. In this Brown case, the 5th Circuit has now set a deadline for AG Bondi and the DOJ to file their opening brief on the appeal. That means that AG Bondi and her office are now on the clock. And not only do they have to decide what they want to do in this case proceeding forward, do they want to continue to challenge this, do they want the appeal to proceed forward in the 5th Circuit, but generally we're going to get some ideas about what their policies are, what their positions currently are when it comes to machine guns and these types of laws. This case is U.S. versus Brown. Like I mentioned, it's now in the 5th Circuit. And what happened in this case is the lower court judge there stated and ruled that Section 922.0 makes it illegal to possess a machine gun unless the machine gun was lawfully possessed before the date of this subsection takes effect. He then stated that, as Judge Brooms explained in the U.S. versus Morgan case, the statute criminalizes the mere possession of such weapons without regard to how the possessor uses them. If an individual purchases such a weapon and locks it away in a gun safe in his basement for 20 years without even touching it, he is guilty of a violation of Section 922.0 as one who takes the same weapon out into the public streets and displays it in an aggressive manner. So here the judge says that the law there, the federal law, as it's established and as it operates, the mere possession of this item is just categorically restricted unless you go through the proper avenues. And it doesn't matter whether or not you have it and you possess it and it just simply sits in your safe within your home and you never do anything with it. You are treated the same way as someone who maybe illegally gets a machine gun, and then goes and commits horrible atrocities. You are treated the same way under the federal law, and he finds issues with that. The judge went on to state that because he was never convicted of a felony, Mr. Brown argues that the Second Amendment protects him from criminal prosecution under these statutes. He is, in other words, bringing an as-applied challenge to his prosecution. Mr. Brown's argument was once foreclosed by decades of precedent, not anymore. In 2022, the Supreme Court established a new historical paradigm for analyzing Second Amendment claims. Every appellate court's prior precedent was rendered obsolete. Under the new standard, the government must prove that its desired firearms restriction, which here means the statute criminalizing simple machine gun possession, is consistent with the nation's historical tradition of firearms regulations. This is a heavy burden, the judge says. The government found this out the hard way in the U.S. versus Morgan case. There, Judge Brooms observed that as Congress did not ban machine gun possession until 1986, the modern ban is inconsistent with the history and tradition of our nation. Even today, in fact, it is perfectly legal for a person who has not been divested of his firearms rights under some other provisions of federal law to acquire and possess a machine gun, so long as it was lawfully possessed by someone before the relevant date in 1986. Now, I want to stop here because there was also a very important distinction that happened in both the U.S. versus Morgan case and this case, U.S. versus Brown. The judge here in this Brown case pointed out how the Morgan legal battle was ruled on by the judge there kind of in a very specific way because the federal government just outright failed to provide historical justifications under Bruen for this type of machine gun restriction. When reviewing the federal government's justifications in the Brown case, the court stated that most of the government citations for those arguments are judicial decisions that predate Bruen. Many of its remaining claims, which focus on the benefits to public safety of machine gun bans, are policy arguments entitled to no weight. Bruen held that the Second Amendment does not permit judges to assess the costs and benefits of firearms restrictions under means and scrutiny. So here the judge is saying Bruen rejected, policy arguments. It rejected the balancing of interests, and here he has to reject it as well. It doesn't matter what the federal government says, the public's interest really is. He has to reject it under Supreme Court precedent. The historical justifications that the federal government actually presented in this case with the machine gun prosecution in Mr. Brown's case, they included things like the Statute of Northampton relating to the riding or going armed offensively to the fear or terror of good citizens, but the judge here rejected all of those, saying that they do not apply. He stated that these examples might support the prosecution of a person charged with terrorizing others with a machine gun, yet they provide no support for the prosecution of Mr. Brown. The government does not allege that he did anything against the public peace. Mr. Brown was not armed offensively, nor was he attempting to terrorize the good citizens. He wasn't going or riding anywhere. The government's brief instead admits that the machine gun was within his home. None of the government's proffered historical regulations, however, are relevantly similar to criminalizing possession of a firearm within one's home. If anything, the American history and tradition supports Mr. Brown's possession of a firearm within his home. Bruen nevertheless tells us that there is an American historical tradition of prohibiting the carrying of dangerous and unusual weapons. That is the law to be followed. The ultimate problem for the government then is this: although machine guns are dangerous, it does not explain how machine guns are unusual. Here the judge is pointing out that potentially all firearms in essence are dangerous. They're dangerous in some way, of course, because they're firearms. But the federal government must also show that they are unusual as well in some way. But here the judge found that the federal government did not meet that burden under Bruen. The judge pointed out that the record in this case shows there's about 740,000 machine guns that were recorded and are lawfully possessed as of 2021. He stated that 740,000 is no small number. The government presents no argument or explanation for why such a large figure is somehow not common. Now, to contest that number of machine guns in common use, the federal government relied only on a Fifth Circuit case called Hollis. However, that case is now invalid under Bruen, and also the number of machine guns presented in that case were only about 175,000. However, now with Bruen in the clear counting of at least 740,000 machine guns, the judge here found that the Hollis case is unpersuasive, and based on that, he agreed with Mr. Brown in his as-applied challenge and granted his motion to dismiss the case based on the Second Amendment. Now, the U.S. government decided to appeal that decision to the Fifth Circuit, where it's currently at, but now the Fifth Circuit has ordered that AG Bondi and her office need to file their opening briefs by May 12th. Because of that, we will soon see actually what the AG's office and what the Trump administration's actual position is when it comes to machine guns and these types of possession charges. Are they going to proceed forward in this case? Are they going to just let it go and let this precedent sit, not just in the Fifth Circuit, but the 10th Circuit? And what just generally is their policy going to be when it comes to machine guns? If her office decides to proceed forward in this challenge, arguing that the decision striking down Mr. Brown's machine gun charge, that it should be reversed by the Fifth Circuit, she will no doubt catch a lot of blowback from the 2A community, because then they would be defending, the machine gun laws, saying that they don't violate the Second Amendment. And of course, that does not align with Trump and what he said during his campaign, that they're going to protect the Second Amendment. And it also doesn't align with the executive order that he issued, that they are aiming to protect the Second Amendment. Now, the good thing with this appeal and the current deadlines that have been set for these briefs is that very soon a light will be shined on all of this. The very hot topic of machine guns and possession of machine guns, will be brought up, to the Fifth Circuit. So it's going to be a clear record, and it's really going to test how pro-2A this new administration really is, and what, AG Pam Bondi, what her position really would be when it comes to the Second Amendment in this issue of machine guns. So this is a critical decision and a very important actual appeal in the Fifth Circuit, and we're going to get some information on how this administration is going to handle machine guns going forward and how they're going to handle these types of lawsuits going forward. So as we get more information, as they file that brief and we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.